Your latest Murgitroyd webinar will start in a few moments. For more information on today's panel and our company, visit murgitroyd.com/webinars.
Hello and welcome to the 8th series of Murgitroyd online seminars. We are delighted to reconnect with our regular listeners and a warm welcome to those of you tuning in for the first time. Our webinars are here to keep us all up to date on the latest developments in the world of IP. Please don't forget you can submit questions via email at webinar@murgitroyd.com. You can also contact us by Twitter using #MurgitroydWebinars, and remember to tag us at Murgitroyd. So, let's go straight into today's webinar.
Welcome to Murgitroyd's second CRISPR technology briefing. My name's Russell Thom, and I'm Regional Head of Patents for UK and Ireland. Today I'm joined by my colleague Cath Coombes, who leads the CRISPR technology team in Murgitroyd. Cath has a long experience of working in the CRISPR technology field, back to 2006, and then more recently in also providing comment on patent decisions. We're going to discuss a recent decision issued by the European Patent Office Board of Appeal in a landmark CRISPR technology case. Our aim is to discuss this and then distill down some of the practical tips that you can use in your practice and day-to-day activities. So moving into discussion, welcome, Cath.
Thanks, Russell. I'm really delighted to be here today to discuss this appeal decision in more detail as part of our follow-up from our earlier CRISPR webinar.
So those working in the CRISPR field will have been aware of ongoing disputes about the rights to commercialise gene editing technology. The EPO has recently clarified its reasoning behind the decision of one of the most high-profile cases in recent years. I thought it would be useful to look at this in a bit more detail and whether there's any practical considerations that we should implement in view of these documents and comments. I know you've been actively working in CRISPR for a number of years, so how did you come into this field and what have you seen over that time?
I first came into this field through the natural mechanisms for CRISPR. So CRISPR is actually part of adaptive immune system in bacteria. And so I was working on utilisation of that in food production. So modulating a bacterium to have increased resistance to phage, which may spoil the food. So that's how I started off in maybe 2006, 2007. And of course, since then, it has exploded with the recognition that actually these elements from a naturally occurring system could be used to edit genes. And the appeal that we're going to be discussing today, Russell, is one of the early patents in this field and the lead patent for that group for CRISPR-Cas9 use as a gene editing tool in eukaryotes.
Good. So you really were an early adopter before most patent professionals started to pick up on CRISPR as it became an ever-increasing tool that people are using. So just before we look in detail at the most recent EPO written decision, I wondered if you could set the scene for us. For this case, who were the parties and how did we get here?
So the earliest priority filing for this particular case, which is EP 2771468, involved 8 inventors who were authors of the seminal publication for the group Kong 2013. And when this PCT application was filed, it was filed with only 4 of those inventors being named, and in the name of 3 of the 4 potential co-applicants deriving rights from those inventors. And this went through opposition, and ultimately the patent in opposition was revoked on a formal requirement for priority not being met. I've got a slide here that illustrates the early type 2, which is what CRISPR-Cas9 is a type 2 CRISPR system field. And each circle represents a priority filing from the group of 6 in the field. So the first thing you notice is this huge interwoven nature of priority filings. And so it was key for every group to maintain their earliest priority right. And because, unfortunately, these formal requirements for priority weren't met, it meant that their own publication and some other key publications became citable against a patent. and ultimately the patent was revoked for lack of novelty. And so this appeal is actually discussing in much greater depth those formal requirement of priority aspects at the EPO.
So with priority, we have a first patent application, and there can be the right to file a priority claiming for the same invention within 12 months and gain the benefit of that earlier date. A valid priority means that any public disclosures made after the priority date will not count as prior art against the patent. So at the EPO, priority is governed by Article 87 EPC.
Mm-hmm.
What went wrong in this case?
So there were 8 inventors on the earliest priority application filed on the 12th of December 2012. And these are considered a single legal entity in terms of priority due to T788 of 05. And Article 87 allows a successor in title, as you mentioned, Russell, to file and claim that benefit of priority. But in this case, as is quite standard in the US, after the initial priority filing was filed, they decided to analyse the earliest priority document and what inventions it contained. And in fact, Broad ended up filing no less than 10 different PCT applications on the same date, all claiming priority back from the earliest priority filing. So that earliest priority filing had at least 10 inventions in it. And when that inventorship determination occurred, there was a fallout between the parties. Luciano Marafini, who's shown here in the bottom left, he was considered not to have contributed significantly to CRISPR-Cas systems as applied in eukaryotes. And he disagreed with this, and his institution, Rockefeller University, disagreed with this. And because of this, there was silence between the parties, and the PCTs were filed without express permission from either Luciano Marafini or from Rockefeller University. And we know all of this because, quite unusually, in the US, Rockefeller University filed an application adding themselves as a co-applicant and Luciano Marafini as a co-inventor. And in that dispute about that application being filed, a declaration was put on file outlining these circumstances, which made it clear that there was no transfer of priority right from either Luciano Marafini or, once he had assigned his rights to Rockefeller University, from Rockefeller University to these applicants. And so we see that breakdown of successor in title.
And this wasn't detected during the patent prosecution of the European patent. It was during the period after the patent was granted, and you can make third-party oppositions to a European patent. That's correct?
Yeah, absolutely. The formal requirements for priority, as you know, are part of the EPC, but typically the EPO considers that they are met unless they're given good reasons as to why they're not. And what you tend to find in oppositions particularly is opponents will go on to the public pair of the USPTO to look at those assignments to see if there's any discrepancies which might indicate that these formal conditions for priority aren't met. And those typically are the fact that the assignments have occurred too late, so after the filing date, because this needs to be in place at the filing date. It can't be rectified later.
In this case, the opposition was successful. It was obviously some time ago now. I assume the patent proprietors, because it's a high-profile case, appealed, and that leads us to where we are now?
Yeah, absolutely. What actually happened at the time was, during the opposition proceedings, the result of an arbitration proceedings between Rockefeller University, Luciano Marafini, and the other parties was announced, which concluded that it was correct, the inventorship determination was correct, and he shouldn't be named as a co-applicant. And they tried to use this in the opposition to come to a favourable decision. But the opposition division held a concept that we call an all applicants approach to priority applied. And so later on the same day, it was announced that they were appealing. And it went to a 4-day hearing back in January, where we were discussing in great detail these formal requirements for priority, whether the EPO should consider formal requirements for priority at all. If they do, what the interpretation should be for any person in Article 87. And should national law apply? So should it be the US law that applies to determine it because the priority document was filed in the US?
Okay, so on those 3 points then, obviously the decision really just followed what was existing European case law. So it seems as if it really just helps clarify the approach the EPO will take in these matters rather than provide any surprising differences and changes in existing case law. Is that right?
It certainly followed what we've understood the form of requirements to be for a significant number of years. I think it was a great test for the formal requirements of priority. A lot of new and interesting points of law had been raised, consideration about whether this all-applicant approach was incompatible with Article 4 of the Paris Convention.
So the decision then was perhaps expected given the case law of the EPO. But the written response from the Board of Appeal does help reinforce the approach the EPO will take. There was 3 main arguments advanced by the parties during the appeal proceedings. Was there anything more that we learned from the written proceedings that help give guidance now as to the approach applicants should take?
Yeah, so there were lots of interesting points of law that were raised before, because whilst we did have an established system for the assessment of priority, it didn't fit specifically the facts of this case. And there hadn't ever been a very robust, reasoned decision about why the formal requirements of priority were there. The closest they got to that was the decision in T788 of 05, which has been consistently followed. But in terms of actual reasoning as to why there should be formal requirements, that wasn't found in that decision. And so the appellants in this case try to bring forward 3 kind of reasonings for why we shouldn't have formal requirements. Firstly, that we shouldn't really consider having formal requirements at all at the EPO. The reasoning behind that is it's tied in with the entitlement proceedings, which the EPO acknowledges should be a matter for national law. And the appellant's arguments here was that it was a property right, and dropping the formal requirements wouldn't cause uncertainty for third parties for a couple of reasons. Firstly, obviously you have certain criteria you have to meet anyway in order to be able to claim priority. You need to know the priority number, the date it was filed, etc. And that information isn't in just anybody's possession because obviously it's not publicly available. So there must be some kind of connection in order for you to be able to fulfill those sorts of requirements within the EPC. They were saying that it wasn't harm to third parties because as long as you assess whether it's the same invention, it doesn't matter to the third party who owns the patent, it's the fact that there's a patent there. So it shouldn't affect that. Those were rejected by the Boards of Appeal of the EPO. And in their reasonings for it, it seems that just because you might be able to work your way around it doesn't change the fact that actually this is part of the EPC. Article 87.1 is there, and that they don't give any good reasons for why that shouldn't apply. There was arguments that it was inconsistent with the Paris Convention and Article 4 of the Paris Convention specifically. Again, the language is exactly the same between the two in terms of the words. So this argument was more about the all-applicant approach, so considering them all a joint legal entity, as opposed to the opposite, which would be anybody who was named on a priority filing then be able to file their own patent application and claim priority. Now, the EPO had never gone into a great deal of detail about why the all-applicant approach was there. And the board spent a lot of time looking at the specific language, particularly the French language that was used in the Paris Convention. They pointed out that there's been at least 7 reiterations of the Paris Convention since it was originally written. And none of those revisions was there any suggestion that the all-applicant approach was inconsistent with the intentions behind the Paris Convention. So they were key considerations that they put into play. But for me, reading the decision, I felt that the main position of the board was that if you were to take the opposite view, then you might put a co-applicant in a difficult position in that the only recourse that a co-applicant could have if one of their co-applicants decided to go off without them and file a patent application in their name alone, would be very expensive and costly entitlement proceedings in various jurisdictions. And the board felt that that was off, and surely that wasn't the intention behind the Paris Convention. The third kind of area where arguments were put forward was the fact, obviously, this was a US priority application. And that's distinguished from T788 of 05 because in that case, it was a member state of the EPO. And so there was a talk of internal priority and external priority. So when the priority is from a member state outside of the EPC and isn't applying the EPC rules. And the arguments behind this was that it would have to affect a change of US practice because a priority application in the US can contain multiple inventions, doesn't have to have any claims at all. But in terms of the minute you put claims on file, that has to be linked with who contributed to those claims, and the applicants flow from that. So in the US, you don't have separate right of entitlement and a right of priority. That doesn't exist. And so the arguments were essentially that you have to use the US law, otherwise you're treating unfavourably because the system is different there. That was rejected as well. And it was pointed out that, yes, all countries should be treated the same. And so actually applying the law of the EPC consistently, irrespective of where the priority document from, was treating everybody the same. And it was pointed out that obviously the USPTO is party to the Paris Convention and had signed up to that language, the identical language in Article 4A of the Paris Convention. And at one point, actually, the board, given their decisions, became quite blunt. And they concluded that it wasn't for the board to put right an omission, mistake, or deliberate choice of a party.
Thanks, Cath. So obviously a really detailed opinion now that we've got back from the EPO, and thanks very much for going into the detail there. Just to try and unpack that a bit then and give a more practical aspect to people dealing obviously with this going forward. It sounds as if these formal requirements are looked at during oppositions, as you say, because the assignments, we can look at them on public payer, on corresponding US patent applications and patents, and look at the difference that, if there are any, that there might be in relation to the European Patent Office. So it sounds as if this may be something that will affect other patents or pending applications in the field. Would you agree that this isn't a one-off circumstance just for this patent?
I would completely agree. In fact, if we actually look at some of the other co-applicants on that priority document, the focus was on Luciana Marafini because of this declaration, but there are issues with actually 5 other co-inventors here. For 3 of them, the issue was very minor in the sense the assignment was affected before the filing date, which is correct, but it had the PCT number there. And as we know, you only obtain a PCT number once you file the PCT. So there was a slight discrepancy there. And that was picked up by most of the opponents and brought to the attention of the EPO. For 3 other of the co-applicants, they had all assigned over correctly after the PCT filing date. Again, there was the issues with the formal requirements for those 3 too. And this is something we consistently see. I think that, some of these issues could have potentially have been gotten around. Some of the assignments on the USPTO could have been confirmatory assignments. And actually, the chain of when that right of priority passed may have been a different date. Having the declaration there was obviously the key evidence in this case. But when we think of collaborations particularly, and we think also, we often find that there's a mad scrabble just before filing date to make sure you have all the assignments in place to ensure that you have this correct chain of title. And so I guess we could think about some of the practical things that we can do for that. So sometimes you don't know whether the assignments occurred in time or not. So what do you do then? I mean, one option would be to name both the inventors and their institutions all as co-applicants, and then of course decrease down as appropriate when you find out when that assignment occurred. And that will protect your right of priority.
So a consistency there in relation to the applicants at the priority date and then the applicants at the PCT filing as well.
Yeah, absolutely. I mean, this priority issue always occurs when you've got a decrease or a change of some kind. So it's not something that you need to be really concerned with if you've added more data and there are additional inventors and additional applicants. That's not a problem at all from a priority perspective. It's where there was somebody who was named on the priority document, and then when you file your application, they're not named. And you need to ensure that that right of priority has transferred across. And if in doubt, add them on, because you can take them off as a co-applicant later of a PCT. That is rectifiable. Having this broken chain in Europe isn't rectifiable. We can't do anything past the filing date. There is one kind of get around in certain circumstances. So, for example, in the UK, you could bring entitlement proceedings and request that they are considered prior, as if it's always been that way, and that could overcome it. So there are occasional ways round, but they're costly and they're difficult to do. So practically, always ensuring that's the case, and if in doubt, putting more on and then taking them off as a co-applicant or PCT is the way to go, really.
Thank you. So yes, if where you have more than one party at your priority filing, then ensuring either that they have transferred their rights before the PCT application and that has been enacted in a way that will be suitable for the EPO, or as you say, keep both parties or all parties on the application as applicants during the PCT stage and sort it downstream in the prosecution. Are there any other practical comments that you would say that people should consider? And during due diligence, how should they perhaps look at this and consider if this issue will apply then?
Whenever there's IP collaborations, there's potential for various issues. It's not ideal to have co-applicants. It makes procedures more difficult going forward. So I would say at the point of collaboration, that's when you really want to be considering, why are we collaborating together? Who's going to own the IP out of this collaboration? Who's going to be filing and handling the prosecution for this? And getting those agreements from outset, so everything's in place and correct assignments can be effected quickly, would be definitely something that I would recommend where possible.
Thanks very much. Obviously, CRISPR has many different applications, and the awarding of the Nobel Prize for Chemistry recently in October 2020 for this work really underlines this. Given your long experience in the field and obviously working closely with different companies, what do you think the current issues for CRISPR are in relation to intellectual property? This application and patent obviously focused on Cas9. Where are we now?
We've got over 6,500 patent applications for CRISPR technology at the moment. So we're in very murky waters. And I think one of the biggest issues for most companies working in this field is how do you even begin to go about getting freedom to operate? There's been lots of collaborations that have occurred for agricultural side. There's been talk about a patent pool, and hopefully that would be going ahead. And I can see that going ahead for the likes of the reagents. Merck and Sigma and Broad have got a joint kind of collaboration agreement, so you can get a license from those parties, for example, for reagents. But in terms of human therapeutics, it becomes very tricky indeed because of the requirements that in order to incentivize those clinical trials that you're looking for exclusivity. So how you can navigate this space right now is quite problematic. And it's something that I think won't become clearer for several years to come, to be frank.
Okay, so a very active field for patent applications and patents at the moment. And so taking some care, and if you want to move into that commercial field and really look in depth and be guided through the difficulties and the challenges that might be faced is key.
Yes, I think it's great to have a look at the landscape whilst you're considering what you're wanting to achieve. in this field, when the earliest patents were filed, we were talking about type 2 CRISPR systems, which utilise endonuclease called Cas9. And that was because at that stage, that was the only known class 2 CRISPR system. So class 2 CRISPR system means you're utilising one enzyme for both binding and cleavage. Since then, there's been type 5 and type 6 systems discovered. So it's tripled the classifications for class 2 systems. And that adds complexities, but it also adds opportunities, because some of the more recently discovered systems will not fall within the scope, potentially, of a number of these earlier patents. So when you're considering which systems to utilise, how to conduct your research, it might be beneficial, as well as thinking about your aims, thinking about which spaces within the landscape are less heavy and where there is more room for manoeuvre, and directing your lead candidates towards those sorts of areas. The other thing I'd say as well is, I think in terms of hurdles for this field, one of the key hurdles that we are seeking to overcome is the delivery aspects. How do we get these components into our cells, into the lung, for example, in the correct way, so that they're only activated when we want them to activate together? And these challenges have yet to be solved. And I'm of the firm opinion that the key patents in this field I've yet to read. Because from a regulatory standpoint, when we come across those key patents that can overcome these delivery aspects, can overcome potential problems about off-target effects. So that's where we unfortunately bind to the wrong section of DNA within our genome and then affected a change somewhere we don't want to affect a change. Obviously undesirable when it comes to therapeutics to do that. So once we have further developed, and the field is developing at a huge pace in these areas, those sorts of things I can see from a regulatory standpoint becoming mandatory. And so they're going to be the key patents in the field.
So Cath, obviously we've been speaking about one important European patent in this field, but there are other patents in the CRISPR-Cas9 field. And in particular, the University of California, Berkeley are a bit of a player. For the corresponding US cases, obviously there's been much toing and froing in terms of interference. Can you describe a little bit of the stage in Europe for the University of California, Berkeley patents?
Yeah, so the University of California, Berkeley patents, the lead inventors for those are Jennifer Doudna and Emmanuel Charpentier, who won the Nobel Prize for CRISPR-Cas9. And they have 3 key patents in Europe. The lead one of that, EP 2800811, that survived opposition relatively unscathed with very broad subject matter, and it was considered to be entitled to its earliest priority filing, which is complete contrast to how the PTAB is considering the same priority filing in the US. In the US, they consider that there wasn't an enabling disclosure based on the earliest priority application, in fact, based on the earliest 2 priority applications for them. So at the moment, that's undergoing appeal, and the opponents have argued strenuously that that decision was wrong and that there isn't enough information in the priority application to have an enabling disclosure for the very broad scope that's claimed. These are composition claims that are much broader than using CRISPR and tracer RNA. They mean much broader than that. And that's ongoing. The divisional of that has been called to oral proceedings in opposition. And it seemed to be very much following what was happening with the parents. So initial preliminary opinion came out, finding there to be entitlement to priority, and that priority was an enabling disclosure. And this patent centres on using CRISPR systems as a tow truck, effectively. So you're adding a heterologous protein of some kind, and that's carrying out a function in the genes. But because of COVID, we've had lots of opposition in person cancelled and being rescheduled. I mean, that is coming to a standstill now because we've had a recent decision that actually proceedings will be occurring by video conference. It doesn't need confirmation by all parties going forward. So this has now been rescheduled for April. But a new preliminary opinion came out with that rescheduled date, and it's now following much closer to what we're seeing in the US, and it's considering that it is undue burden to work the invention across the scope based on the priority filing. And the reasons for this are really the examples in the earliest priority filing wasn't in a eukaryotic environment. It showed some cleavage, and some key information wasn't there in the earliest priority filing. And that's to do with what we call the protospacer adjacent motif. Now, that's terminology that comes from bacteria and its use in a bacterium as a defense mechanism. So when the CRISPR RNA binds to a target, there needs to be on the opposite strand in the near vicinity what's called a protospacer adjacent motif. And effectively, the Cas9 enzyme recognises this and then undergoes the conformational changes needed to pull the two strands apart to affect the cleavage. So if a PAM motif isn't there, the Cas enzyme's not going to undergo those conformational changes, and then it can't cleave effectively. And there was nothing in the earliest priority application about this requirement for a PAM motif. And there was a lot of argument during the opposition proceedings about whether this could be considered common general knowledge. And there's lots of other aspects. So, for example, you have a certain length of section of the CRISPR RNA which will bind to the target. Now, how many mismatches you can have and for cleavage still to occur isn't disclosed in the earliest priority filing. What kind of changes you could have to the Cas9 enzyme and for it to still function, what conserved residues are within that Cas9 enzyme wasn't disclosed because the mechanism of action of Cas9 wasn't fully elucidated at that filing date. So all of these different factors can add together, and you can consider it to be undue burden for a person skilled in the art, because if it doesn't work, is it not working because there's no PAM motif? Is it not working because actually in your binding segment you have some mismatches where you can't have them? Is it because you've got some slight changes in your Cas9 enzyme? Is it because you're using a Cas9 enzyme, a naturally occurring CRISPR RNA, but they don't naturally associate with each other? So you're using them from different bacterial systems? There's lots of different issues that could cause it to not work. And the combination of those, the argument would be that that is undue burden. And I think the big change that we've seen in this preliminary opinion is probably down to some arguments that were made which pointed out that if we're considering common general knowledge, what is the invention here? And the invention here is using CRISPR systems as a gene editing tool. And it wasn't known to use CRISPR systems as gene editing before. So when we're considering who the skilled person should be, the fundamental question is, should there be somebody who is an expert on bacterial CRISPR systems as part of the person skilled in the art? If you don't know that it's actually CRISPR that you need to use to come up with an improved gene editing system. And that's how the opponents are running the argument, and what seems to have brought a change in opinion for this divisional. So that's really interesting, and it's particularly interesting how those sorts of arguments will affect the appeal as well on the lead patent. And as I said, we're going to hear the conclusions of the opposition division on the divisional in April. So that's something to look out for.
Thanks. So the preliminary opinion really just providing an indication of the division's thinking at the moment, now that they've received the comments from both parties. And as you say, the next proceeding will be early next year, and that allows the parties to orally present their arguments in front of that division, which will lead then to a decision. So we should expect further developments next year, and we're all looking forward to that, to see where this story continues from there. Well, thanks again, Cath. That's fantastic. Great to have insight into another of these cases, obviously in the same technical field. Thank you.
Thanks for discussing this with me today, Russell. And if anybody's got any further questions about anything that we've covered here, then please don't hesitate to get in touch. We'll be happy to answer them as best we can.
We've reached the end of today's presentation. To find out the topic of our next webinar and to register, visit murgitroyd.com/webinars. And whilst you're there, why not keep up to date with our latest content by subscribing to our mailing list? Thank you for your valuable time today and for all your questions. We hope you found the subject matter relevant and well explained. Should you have any other questions or wish to discuss the topic further, please contact us at webinar@murgitroyd.com or via Twitter @Murgitroyd. Until the next time, goodbye.
Our business is founded on trust and collaboration. The subjects we choose for our webinars are topical and informative. We are always looking for suggestions for new topics for discussion. So if there's an area of IP that you are keen to understand better, please drop us a line at webinar@murgitroyd.com.